Your IEEE membership means access to insurance products featuring exclusive group rates, flexible benefit options, and portable coverage that stays with you throughout your career. Engineered to help protect your loved ones and your financial security. For more information, go to IEEEinsurance.com.
Good afternoon, everyone, and welcome to today's IEEE-USA webinar, Patents, Trademarks, and Copyrights, Essential Strategies for Entrepreneurs and Businesses to Safeguard Innovations, Designs, and Brands. I'm your host, Jonathan Cho. We're proud to have the IEEE Member Group Insurance Program, powered by AMBA, as our sponsor for today's webinar. Please note that this webinar is not affiliated with or endorsed by our sponsor. Our presenter for today is Peter Weissman. Peter is a partner at the prestigious national law firm Blank Rome LLP, where he specializes in the worldwide protection of intellectual property, including patents, trademarks, designs, copyrights, and trade secrets. He advises startup and Fortune 500 companies on IP procurement, growth, risk avoidance, infringement, litigation, and portfolio management, due diligence for acquisitions, transfers, and funding, technology transfer and licensing, and trade secret and copyright protection. Peter previously served as a patent examiner at the U.S. Patent and Trademark Office and is a regular speaker at various conferences and workshops on IP protection and entrepreneurship. Without further ado, I will now pass it off to our presenter. Welcome, Peter. We're very excited for what you have in store for our audience.
Thank you very much, Jonathan, and thank you to IEEE for having me speak today. It's really a great pleasure to be here, and I hope you find my presentation to be informative. I'm going to jump right in. We're going to be talking about intellectual property today, and here's just a brief overview, a roadmap, if you will, of what I plan to discuss. First is the concept of patents. A patent, generally speaking, and I'll get into this in more detail, it protects the implementation of an idea, so a patent can be a device, a system, or method. A trademark, in contrast, protects anything that identifies your goods or services. So Coke or Oreo, things that you come to recognize as a term or word or a symbol that tells your consumers that this product is coming from the same location. Copyright protects an expression of something that's fixed in a tangible medium. Oftentimes we may think of copyright as protecting songs, but it can also protect source code, books, videos, things on your website. And then finally, trade secret is proprietary information that you decide to keep confidential. And these types of things, maybe you cannot get a patent for, or maybe it can be patentable, but you think that perhaps you can get longer lasting protection if you just keep it as a trade secret. And feel free to ask questions along the way. I'm not sure I'll be able to follow all of it as we go through. I'll try to take a break after we discuss patents and before we jump into the next section. If you have any questions at that time, we can go through those. So getting more into detail on what is a patent, that's the first question that people tend to ask me. What is a patent? Well, a patent there are three types of patents: utility, design, and one I didn't list here, which is a plant. A plant like you would grow a plant, but that doesn't really apply in too many instances. So a utility patent, it can be anything. There was a Supreme Court case early on that said a patent can be obtained for anything under the sun. So anything that you feel is an improvement of what's been done before can be a device, it can be a machine, a method, all the things I listed there, composition of matter, it can be chemical inventions, biotech inventions, software, certain types of software, which we'll get into. Design patent is a little bit different than a utility patent. The design patent only covers an ornamental, non-functional product feature, and I'll show you some examples of those in a minute as well. So the utility patent is a full description of an invention. It has a lot of figures in it and text describing what the invention is. A design patent is only images, so a design patent is much less expensive to file, but it also has a limited protection as well. Well, a patent, it confers rights to you of preventing competitors from making, using, or selling, importing similar product. So a patent doesn't give you a right to do anything other than to prevent your competitors from doing the same thing that you claim as your patent. So it gives you exclusivity for the period of time that the patent is valid. I have here a couple of examples of patents. These are both some patent was obtained for both a system and a method. This was a refrigerator product line. So it's not only the refrigerator software, but the method of producing the refrigerator as well. So that gives you an example of system and a method type of a utility patent. Device patent can be for a fan motor. It can be for anything really. I mean, it could be a stapler. It could be anything simple or complex. There doesn't have to be any type of level of utility to it with respect to the subject matter. If it's a device or machine, it's something that you can protect. Software, again, we'll get into this a little bit further, but software can be protected. It's been more difficult to do so. About 15 years ago, there was a Supreme Court case that came out and limited patents to certain types of software as far as being patent eligible. And then here are a couple of examples of design patents. As you see, it's just going to be images. There's not going to be any text really other than the title of the patent. I show you a couple of examples here of things that have been protected by a design patent. There's an icon. You may recognize the Google pin there. That's the subject of a design patent. Certain icons, system GUIs. So that was the first question. What is a patent? And essentially, a patent is something that gives you exclusivity for a period of time. Well, what can I patent? Right? People always call me up and say, "Can I get a patent for this?" And that's really a two-part question. The first part is the subject matter qualify as patentable subject matter? And about 20 years ago, I never even addressed this part one because the answer was always yes, you can get a patent on everything. But like I said, about 15 years ago, there was a Supreme Court decision that said that certain types of software are not patent eligible. So the subject matter is not eligible for patent protection. Even if it's unique, novel, nobody's done it before, it still needs to be eligible for patent protection. It has to be patentable subject matter. But other than that exception, you can get a patent on a process, a machine, manufacturer. Like I said, I showed you some examples of systems and devices. Design patent, I showed you examples of as well. What cannot be patented? It's the abstract idea, which is a certain type of software. You may hear that term. It's the way that they define abstract idea is not what you might think of in ordinary English terms. It has a lot of interpretation as to what type of an invention is an abstract idea and what is not. The important thing to remember here is that it's a very nuanced area. It's even though the Supreme Court ruling came out 15 years ago, the Patent Office is still struggling with what exactly does that mean? What is patentable and what is not as far as software goes? And there's a lot of inconsistency at the Patent Office as well, unfortunately. I've had situations where we have a rejection from the Patent Office saying that our invention is not patent eligible, and we'll have a call with the examiner, and the examiner says, and I ask the examiner, you reject this on prior art that is that just issued recently. How come they got a patent and we can't? And the examiner said, well, that's the guy down the hall. He's issuing these patents. I don't know why. So there's a lot of inconsistency at the patent. There's a lot of confusion there, unfortunately. So the best thing to do is try not to make your own assessment as to whether or not something is patentable subject matter, but talk to an attorney about that to make sure whether or not the idea that you have in mind is patentable or not. Laws of natures and discoveries. You cannot get a patent on something you've discovered. You can't get a patent on the discovery of electricity. It's the application or the implementation of using the electricity in order to build some sort of a product, whether it's a light bulb or a stereo or whatever it is, using that discovery in order to make a real world application. So that was the first part. Is it patentable subject matter? Is it eligible for protection at all? And if you pass that test, which most of the time you do, I mean, like I said, it's only software that presents an exception there. The second part is it patentable over what others have done before? And I gave you the formal test there. You know, it's maybe it's not immediately apparent what is meant by that. The test is whether it's obvious to one of ordinary skill in the art based upon existing technologies. And what the examiner will do is will look for prior art patents or prior evidence of what has been done before. It could be a publication, it could be marketing material, it can be an actual product. Most of the time, the patent office will focus on prior patents that have been filed, published applications, or issued patents. But it's a little deceiving. The examiner is not supposed to. It's not supposed to be a subjective test, but an objective test. So the examiner can't just willy-nilly say that something is obvious. He has to have some proof of that, and the proof usually comes in the form of having these prior examples of patents that have been done before, and reaching a conclusion that one or more prior art patents can be combined together in order to say whether or not your invention is patentable. Well, what's the practical test, right? That's the formal test, but really, it's really a practical test, just like you know, any other type of asset. It's whether is your system different than what's been done before. Does it give you any sort of commercial advantage? Is it worth your time and expense? Does it provide you with a benefit of some sort? Now, the advantage doesn't have to be that yours is better. It doesn't have to be, you know, the top of the line product. It could be somewhere in the middle. But if it's distinguishing you over what others have done before, then that could give you value. So the test that I like to say is it's like any other asset that you're purchasing. If you decide one day that you need to buy new computers for your office and you have to buy 10 new computers, well, what do? You have to balance what is the cost, right? How many for 10 computers at $1,000 each, and maybe $10,000 or maybe $20,000. But what is the benefit you're going to retrieve in exchange for that? Are you going to be able to do things that you haven't been able to do before? Is it going to make everyone's job easier? Can you get new software? Can you will speed up how your work process goes? And that's the same with a patent. If I told you that a patent was going to cost you $15,000 to apply for, well, you're going to think to yourself, oh, well, you know, am I going to get a return on my money there? Am I going to be able to recover that $15,000? Is my invention $1 million idea? Because I feel I could sell more of my product or services based upon that patent and preventing others from getting in. If not, if it is $1 million, then you decide you'll move forward with it. But if your invention is really only a slight advancement on what others have done before, and you feel, well, it differentiates us, but not all that much, then you may decide that perhaps a patent is not really worth it to you. So I'll give you a couple of examples. These are almost a little silly, but these are patents that I came across when I was a patent examiner, and they just kind of stuck in my mind. So this first one is a method for immobilizing an earthworm, I suppose, so that you could better use it for whatever you're going to use it for. And so at first you may look like, well, it's just a sandbox, right? And well, so if you look at the patent a little closer, it talks about that there are certain size granular pieces of sand that will result in immobilization of the earthworm. So that was what the patent was granted for. The second one is a cooler and umbrella assembly. So you see there, you have a cooler and it has a radio in it and it has an umbrella. And this is just an example of, 99% of all applications that are filed today are an improvement. They're improvement of what other people have done before. And this is just a simple example of that. This person didn't invent the umbrella, they didn't invent the cooler, and they didn't invent the radio, but the combination of those things the patent office determined was a patentable concept. It provided certain benefits. Maybe it wasn't obvious. Maybe the way that they arranged those things together resulted in a patentable combination. So not just the fact that the patent isn't going to just be for an umbrella with a cooler and a radio in it. That's kind of a too broad of a concept. It has to be something where the radio is implemented in the cooler in a certain way, and the umbrella is also configured in a certain way with respect to the cooler. Some of you may have heard of what's called a provisional application, and this is a type of a utility patent, but it lasts only for 1 year. And a provisional is something that is less expensive to file most of the time, or it can be if you wish it to be. So people don't always know if their invention is really going to have a lot of commercial value, and they don't want to spend the $15,000 or whatever it costs to file a full application. So what they can do is file what's called a provisional application. It doesn't become a patent. Like I said, it expires in 1 year. And within that 1 year period of time, you have to file the full application, which conveniently is called a non-provisional patent application. But it's a form of a utility patent. It's something that allows you to say that you now have a patent pending, which can be important to let your competitors know that, hey, if you decide to come into competition with me, I have a patent pending on this. And if you're going to invest $1 million in developing this thing, you may have to one day deal with my patent, and I could come after you for a claim of infringement. So patent pending is a very strong message that you can send to your competitors. And especially when a patent is pending, people don't necessarily know, well, what are you going to get a patent on? Well, that's a secret right now. I mean, it may be a secret for a certain period of time. So that sometimes gives competitors less security. I mean, if they see that you have a patent, they can try to design around it. But if you just say it's patent pending, they might not know what you're going to get protection for. So that can be a strong signal to send to your competitors. Like I said, the provisional can be cheaper to file. There's no real strong formal requirements. You don't have to put together what we call the claims at the end of the patent. You don't have to do a full, complete write-up of it. You can basically take a PowerPoint presentation and file that as a provisional application. And that may give you some benefit. It shows what you thought of as a certain date, and you want to make a record of that before you start showing it to other people. And then it gives you a year to figure out, well, is this really something that's commercially viable? Is it worth me to go forward and file the full application? The disadvantages of a provisional, though, is, a lot of people struggle with this. They say, oh, I got a provisional filed, I could do whatever I want. And that's not the case. If the provisional is not a full description of your invention, then when you go to file the full application, and it doesn't provide a sufficient, and your provisional doesn't provide a sufficient description of your invention, then you may not be entitled to rely on the filing date of the provisional application. So the lesson is really, you want to file a full application as soon as you can, but in the event you're going to have something that requires you to file it much faster, a provisional can sometimes be useful, and it's especially useful here. If you remember one thing today, it's going to be this slide and the next slide. And this is something that, when my kids were in kindergarten, they came home and they kind of talked about this. Their teacher said, we have to come up with some invention or some design of some sort. And I said, well, what did they tell you to do with it? And they said, well, you can't tell anybody, right? This is my invention. It's a secret. I can't tell anybody. And that's basically what this rule is. Do not disclose the invention. A single disclosure can trigger what's called the 1 year bar, and you get a 1 year grace period. And a disclosure, again, there's thousands of cases as to what constitutes a disclosure of your invention. it can be a commercial use, even if the use is secret. If you start selling it or ordering commercial quantities of your ingredients or whatever you're required in order to make the product, that can trigger the on sale date. Um, so you just want to be careful of that. But that the rule is that the U.S. once you have this disclosure, the U.S. will give you 1 year to file a full application, or you could do a provisional. Um, the U.S. will give you that 1 year grace period, we call it. But most other countries do not give you any grace period. So that's why we always recommend that we file a patent application in the United States before you disclose the invention. That will preserve your rights to file later. So you file your application in the United States, and then after a certain period of time, you can file the application outside the United States. But if you're sitting there and you're thinking, oh, I already disclosed this, or these are the products we have, and they've been out there for a little bit. If they haven't been on the market for 1 year, you can still file a patent application in the United States. And if your disclosure wasn't fully enabling, or if it didn't describe everything about your invention, then you may still be able to file. It just may be that you'll have to file on improvements that you've made to it less than a year ago. So, but this is the case all the time. I mean, as you go through your business, you're constantly upgrading your product, making, improving it in some way. So you may roll out a product, and 2 years later you roll out another product or something similar, or an improvement to the first product. And what happens is your initial product, or anything that's been disclosed more than 1 year, is prior art to whatever new application you're filing. So just keep in mind that if you do have an invention that you're thinking about, limit who you disclose it to. If you can do non-disclosure, that's good. But the best practice really is to file a patent application before you disclose it. And like I said, if you want to file a provisional, you can get that done quickly. If you're going to disclose, if you're going to bring a PowerPoint presentation and present it at some conference or something, you can file the PowerPoint presentation with the patent office, and you can file that as a provisional and follow it up later with a full application. These are other types of activities that will trigger the 1 year grace period, and could be a problem if you're going to be protecting it outside the United States. So if some people here, if you've gone through your PhDs, you may have done a research paper, a dissertation. If you put it in the library, that could be a publication, poster sessions, things like that. So any time that you're discussing your invention without just in the public, without any sort of confidentiality, and a confidentiality agreement may not always save you. If you have a confidentiality with 100 companies, well, at a certain point, it's not going to be considered, to protect you. It's going to be a disclosure of the invention. Just generally, here's the patent process. First step is always to identify the idea. You may or may not want to do a patentability search. A patentability search is not required, but oftentimes it will give you a lot of good insight into what has been done before and whether you're going to be able to get a patent over what's been done before. Most patents are never commercially released. So in other words, there's no product that's been made that the patent covers. So, oftentimes clients will say, well, I'm very familiar with what's out there in the marketplace, and nobody's done anything like this before. And we'll do a patentability search, and lo and behold, 10 years ago, somebody thought of this. They just never really were able to commercialize it. Getting a patent, I think, is sometimes the easier part of the overall business concept. It's really, a great idea is a dime a dozen, right? So the real difficulty is bringing that to the marketplace. Step 3 is to prepare and file the application. 3 and 4, if you file it with the patent office does a search at step 5. They write you a letter saying whether or not they think it's patentable. And you can kind of cycle back and forth with the patent office in order to argue with them and revise your claims. And hopefully you'll progress on to step 7 at one point where you're actually granted the patent. Some advantages of your patent. So some people, you know, it is an expensive thing to get into, and but there's nothing that requires you to enforce your patent against others. Sometimes it's good to just have it as a kind of establishing a culture of innovation at your company, or showing other companies that you're aggressive in your patent procurement, that you're thinking from a business standpoint. Certainly, if you have an investor, they want to see that you have a patent, want to see that you have a trademark. I mean, if your exit strategy is to sell your company, and you go to an investor and you say, "Hey, yeah, you know, this is a great invention, or my business is terrific. Nobody does it. You know, this is really groundbreaking. I have no competition because nobody's ever seen this thing before." And the investor, what's the investor going to say? They're going to say, "Well, where's your patent?" And if you don't have a patent, or if you haven't filed for a patent, that kind of sends a different message, right? Now you don't, you know, what are you going to say? I didn't have the time for it, or I didn't have the money. The investors are very savvy nowadays, and they're going to want to see that you have a patent protection for what you've done. Because if they invest their money and then all of a sudden a competitor can come into the marketplace and compete with you, it really devalues their investment. I'm not going to go through everything here. I just put up a couple of thoughts here. Establish ownership. This can actually be very important. You wouldn't believe how many times I have this issue, but you know, when we do a patent application, we do an assignment from the inventor to the company. And if you don't have that assignment, and your employment agreement isn't, you know, up to grade, you may have an issue where an employee thinks that they own the patent, and if they leave your company one day, you don't want to have a dispute over who actually owns that patent. You want to establish clearly that it's yours. And same with trademarks. Territorial patents as well as trademarks are very territorial, which means that you have to have a patent where you need protection. So if somebody is making a product in China or Taiwan or Korea or something, and they're importing it into Europe, then your U.S. patent isn't going to do you any good. You're going to need to have a patent in either China or in Europe to go after them where it's making it or where they're selling it. So and that gets very expensive pretty quickly. Even our largest clients don't file in a ton of other countries because the cost really adds up. Patent pitfalls, so failing to protect invention. So, you know, I've done a fair amount of litigation over my time as a patent attorney, and we'll inevitably have a client who gets sued for patent infringement, and we'll be talking with our client about with the researchers or the technical people, and they'll say, I thought of this 20 years before they did, or 5 years before they did. I just didn't think it was patentable. And that's a big problem. I mean, you really need to educate the people who are working on ideas. My favorite saying, of course, is necessity is the mother of all invention. And what that means, if you think about it, is that if you're having a problem or you need something, solving that problem could be something that's patentable. I'll go to my largest clients and I'll be there visiting them to talk about something. I'll say, "Oh, what's that guy doing over there?" "Oh, yeah, he's been working on that." And I'm like, "Well, how come you haven't submitted that to us?" So, people just often, they get tied up in what they're doing, and they don't think about, oh, well, we're solving an important problem here, and maybe we should file for patent protection on it. Inventors should all be within your company. If you have somebody, if you design a website, or if you need to have a product made by a consultant, especially outside the country, and you go to that consultant, or even if you have a rough idea of what the invention is, and you go to somebody and say, "Hey, I need you to help me build this," or whatever. If you are the person who came up with the idea, you conceived of it, you are the inventor. But if you go to this other entity and they come up with an improvement, they started making it and it occurred to them we could do it a little bit better, then all of a sudden they're also an inventor. And if you have that joint inventor relationship, that means that they own it just as well as you, and they can sell it to your competitor without paying you anything. Now, of course, there's business relationships they'll have to deal with, but the best thing to do, and I like to put this right in our non-disclosure agreement for my clients. I like to say, you're going to have a non-disclosure agreement with this entity. Put a clause in there that says that to the extent this consultant comes up with some improvement, that they agree to assign that improvement back to you. I'm going to skip through here. We're running a little short on time. These slides are available too. Certainly you're free to email me. My email was in the registration process. A couple of questions that are coming in. I'm not sure I'm going to be able to take them all in turn. Hairless Monkey Truck asks, so you can patent the idea before you have a marketable product? No. Yeah. So working prototype. So he or she asks, is a working prototype a requirement? It used to be that, I don't know when they stopped the practice, sometimes like in the late 1800s or something. Used to be, and if you go to the patent office, they have a museum there, and they have little prototypes of, little things that people built. It may be the printing, you may see the printing press or something like that there, or various improvements of that. So it used to be that, yeah, you had to have a working prototype, but no. Currently, you don't need a working prototype. You can, and so what we like to say is file early and file often. So if you come up with a concept, there's a certain period of where you need to really figure out what's the best way to commercialize this, what's the best commercial implementation. So you may not want to file on day one, but after a period of time, you may say, okay, now I have a fairly good idea what my invention is going to be, and you can file an application for that. But as we all know, as you start to really commercialize the invention, you really have to figure out a lot of the details, right? And so something you thought might work at the beginning really doesn't work, and you need to change it. So you may want to file, another provisional at that time, and you can file 2, 3, 4 provisionals, and then within the year of the first one, you could kind of combine them all together and claim priority to both of them. So yeah, it's always best. You don't need to start marketing. And actually, if you're part of a company and you have a marketing branch or a sales branch, you want to talk to them and make sure that they're not disclosing things because they're anxious to sell, right? They want to start selling. That's their job. You want to make sure that you coordinate with them to make sure that you file the patent application before they've done that. So Progen Industries asks, if the patent expires, can you refile without improving it? No, the exchange is, I will disclose this invention in exchange for 20 years of protection, and that's 20 years start from the day you file the application. But once that period is expired, the only way you can get additional protection is by making an improvement. And so if you come up with an improvement to that invention, you can protect that. So I think somebody asks here, Bruce McKinnon asks, I was once told that it's a bad idea to attempt to do your own research on a prior art. Do you agree? Yeah, so as I mentioned, I worked as a patent examiner, and there's a certain nuance to searching for prior art. You can go to Google Patents to search for prior art. The Patent Office changed its website as to how you search for a patent. Frankly, I think it's more difficult for the average person to use. Even though I use it a lot, I still find it not as easy to use as Google Patents, for instance. There's a number of other resources that you can use, some paid databases. But we don't do our own searches. It's not economical to do that. There are certain companies that we have relationships with that's all they do. They just search all day long. 7 days, 5 days a week, and that's their job, and you get good at it. I mean, you learn the technique. There's certain things that you can do. There's certain ways to search. Now, I wouldn't discourage you from searching on Google Patents. That's certainly something you can do, and you may find something. But there are professionals who do that, and that we use them as well. Yeah, so somebody, a LinkedIn user asked, can you discuss first to file, first to invent? So it used to be in the United States that the law was who is the first to invent an invention. And that changed several years back so it's really who's the first to file. So if two people have a concept, it's the first one to file with the patent office that has priority, and their application could be prior art to other applications. So that's why we say file early, file often. This all kind of comes from the idea in the United States, right? We want to encourage people to invent things, and we want to give them 1 year to file their applications. So, it's that sexy concept of being in my garage and inventing something that just is a great idea. And, that's the American dream, right? That's the Bill Gates or people who work in their parents' garage, and they come out with this great invention. So that's one reason we give the 1 year grace period from when you disclose it to when you file it. And it also has to do with who is the first to invent, right? A person in their garage may take much longer to develop the invention than a company that could do it much quicker, et cetera. So that's why we used to be the first to invent, but now we move to the first to file system, which is really what the entire world is based on right now, is the most major countries at least. I think I'm going to move on. I'm sorry, I'm going to move on to the trademarks because we're running a little short on time, and I want to get to the trademarks. So a trademark is something that identifies your goods or services and distinguishes it from your competitors. And I love to give this example. So I do a lot of speaking at universities and for entrepreneur classes and stuff. And so I'll talk about how at universities, the student may be excited, they're starting their semester, and they get in their car and they may be located on the other side of the country. They may be in Wisconsin or somewhere else. And they're driving, they get in the car and they're all excited to get to their university to start school. And they're driving a couple hours and they get hungry, right? And they're in the middle of nowhere. I mean, they could be 30 miles from the next rest stop, and they come up, and all of a sudden they see a big sign up in the air. They see the golden arches, right? You have the McDonald's golden arches, or you see a Chick-fil-A sign or something. And what does that tell you? I mean, to me, this illustrates the power of a trademark. You're in the middle of nowhere, and you see this sign that you immediately identify to yourself. If I go to McDonald's, I know exactly what I'm going to get, right? I'm going to get a certain quality hamburger. It may not be the best, it may not be the worst. Frank, I like McDonald's hamburgers. Some people may not, and they may know, well, I'm going to steer clear of that. But I know the quality of the hamburger I'm going to get, the quality of the fries. I'm going to know the approximate cost. I'm going to, it's a fast food, so you know how quickly the service is going to happen. You may just say, oh, it's a place I could use the restroom or something. So it puts that concept. You don't know who's making these hamburgers. You don't know who owns that store, but you do know that it's identifying the source for you. It's a source identifier. It's distinguishing it from the Arby's, which is next door, right? So it really shows that every company has some sort of a trademark. Whatever you're doing, however you're telling your customers, this is my product, this is my service. If you ask for that product by this name, that's your trademark. And I'm not saying every trademark is the same value as other trademarks, but certainly your more important trademarks, you want to file for a federal trademark. And sometimes people get confused. They apply, they start an LLC in some state, and the LLC, as part of that process, gives you a state trademark. Well, just be careful. That's not a federal trademark. A federal trademark protects you throughout the entire country. So it's very, very valuable to have that. Oftentimes it's harder to find a good domain name than it is to protect it with the trademark office. But there, you want to make sure that you do both. And so I'm showing you here several types of trademarks. It can be words, the word Big Mac, the word McDonald's, Coca-Cola. It can be color, brown for UPS. Everybody knows that. Pink for insulation. It can be whatever it is. Whatever you think it can be. The NBC chime, boom, 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 and McDonald's has their da 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 da. So it could be whatever tells your customer this is how you can identify us and distinguish it from others. On the bottom right there, I put in trade dress. And everybody, of course, the Coca-Cola bottle is famous. You may see the Coca-Cola bottle sitting 50 yards away or something, and you can't really tell what it says, but from the shape of the bottle, oh, there's a Coke, right? Or, I used to be able to identify there seemed to be more printers out in the marketplace a while back, and so they all kind of had their own look to it, didn't they? So you could see it across the room, and you may not be able to read it, or you may not be able to see what the name brand is marked on the thing, but you may say, oh, that's a Compaq, or that's a Hewlett Packard or something. And it's the shape of it that really told you. It wasn't anything functional, but customers were able to identify it based upon that. The test here is the likelihood of confusion. And oftentimes people have a difficulty understanding this, but you consider certain things. You consider the appearance, the spelling, the sound, whatever it is that you're looking at. If they're spelled the same way but pronounced differently, well, there could still be confusion there. If they're spelled differently, if they use instead of trademark with a K, it's trademark with a C, or tray dash mark. If it's pronounced the same, it sounds the same, that's not going to be sufficiently different from each other in order to avoid confusion. And that's really the test. That's right. And you don't want a confusing mark either. You want something that identifies your customers. We're not like them. We have our own thing going on over here. Ours is better or different, whatever it is. Like I said, it doesn't have to be the best hamburger. It could be any, it could be just a good hamburger. So it's whatever you're using. You want your mark to be different than other people. This goes to the question we were asked before, but the same thing with a trademark is you can file for a trademark based upon your intent to use it. You don't have to actually be using it just yet, but if early on people love to think, oh, this is great, and I come up with a great name for this product or my business or whatever, you can file a trademark application based upon that right away, based upon your intent to use. But the trademark office doesn't want squatters. They don't want people registering 1,000 different trademarks and never really using them. So while you could register, you file an application based upon your intent to use. The trademark office will not actually register that until you prove to them that you're actually using it in commerce. And with trademarks, you have to be careful. The mark has to be used on or in connection with the actual product or service. So if it's a product, if you're selling a widget or a stapler or something, the mark has to be on the stapler, or it could be on the packaging. So on the box, it could be a hang tag. It could be if it's in a plastic bag, it could be in a shipping container. As long as the mark is somewhere there, if you just put it on your website, that might not be enough. Although there are certain ways you can do that, but you want to be using the mark in connection with the product or the service that's functioning as a trademark, so that people say, "Oh yeah, that's what it is." I give some example here of the types of marks. The trademark is they get kind of categorized, and at the top you'll see it goes from weakest down to the bottom, the strongest. And I just give some examples. But essentially, the more descriptive the word is, or that your mark is, then the harder it is to get protection. So they don't want somebody registering the word chair if you're selling chairs. If you're not selling chairs, if you're selling something completely different than a chair, then that's fine. But if you're using a word that's descriptive of the goods or services, then that can be a problem for you, and you may encounter issues with being able to protect that. So the more creative you can get with the term that you use, the better off you'll be. I put in here a couple of things, our recommendations as far as avoiding certain marks. These occur less often, but these are some of the things that you want to avoid when you're selecting a mark. Just as far as the use of the R in the circle, you can only use that once the mark is officially, formally registered with the trademark office. Mark, once you do, so before then you could use the TM. I thought I had that in here somewhere, but you can use the TM or the SM for service marks, but you can only use the R in the circle once it's actually registered. And that puts people on notice that you consider this your trademark. You can renew the trademark every 10 years, and it can be done indefinitely. As long as you're using the mark in commerce in the way that I described, on the product or its packaging, then you can keep renewing it. And you have to renew it every 10 years. One thing about patents and trademarks is they're very intense on deadlines. There's a lot of deadlines involved in both practices, and it's important that you be aware of what those deadlines are. And we have a whole docketing department here. My firm has a number of lawyers, and so we have a docketing department of probably 5 or 6 people, and all they do is docket these deadlines. They put together every communication we have and receive, they docket it. It's something tied to that activity. So this is just one example. If you haven't docketed to renew your trademark every 10 years, then it can inadvertently lapse and you may have a problem then, and you'll have to refile. Once you do register a trademark, you may want to set a watch service just to keep tabs of what other people are doing. If anyone's trying to register a mark that's similar to yours, you can get a notice of that. A customs recorder, this is often something that, if you have a competitor in another country and they're using your trademark and you have that registered, you can go to the Customs Department, U.S. Department of Customs, and notify them of that, and they could intervene and prevent that infringing product from being brought into the country. You can also register, of course, with Amazon and Google. Keep your registration current. It's easy to just say, "Oh, I have this trademark registration." It's just like everything else. If you go to the doctor and you don't participate in your care, you're not going to get as good service. Same thing applies to patents and trademarks. My favorite client is somebody who asks me a lot of questions. It gives me a lot of confidence that they've reviewed what I put together, that it's correct, that it's accurate, that we've covered all our bases. Don't just rely on me. It's a shared relationship here. You're the inventor. You need to tell me what the invention is, and it's a back and forth process. It takes time and energy to put together an application properly. And same with trademark registrations. You file your trademark, and 5 years later, if you introduce a new product or service, well, that may not be covered by the trademark. You want to make sure that your trademark covers all the goods and services that you're using it on. And same with the countries. If you're now selling in another country, you want to make sure that you file there. And same thing. Trademarks are territorial, so there are trademark attorneys in every country, of course. And so it's not uncommon for me. I would say probably once a quarter, I get an email from an attorney in another country. I have a very specific recollection. I had a small client, and I received an email from an attorney in Turkey. And it was rather unusual. It was, I don't get a lot of emails from Turkey. So they emailed me, say, somebody's trying to register this trademark in Turkey, and we noticed that there's a U.S. Application or U.S. trademark that's registered to a different entity, and this is their way of marketing, right? So they email me, and I'm like, well, let me see what the client says. It's unusual that the mark was identical and the goods were the same. So I emailed the client. I'm like, what is this about? And they're like, oh my gosh, we just spoke to this guy a week ago to be an agent for us in that country. And he went out and tried to register the trademark in his name. And that's a big problem, because if there's a falling out between you and this, whether it's a distributor, a manufacturer, whatever it is, you don't want them to own the trademark. You want to own the trademark in that country. Otherwise, you're going to have a big problem there. So it's much cheaper to file a trademark application now rather than risk the potential of running into a problem like that. That's something where you can kind of be, proactive in getting protection. I'll take a couple of questions here, but I don't have much time because we're running short. How much BTS? How much it costs to file a patent, a new design of device or machine without an attorney? So the Patent and Trademark Office just revised its fees. Currently, there are 3 levels of payment. If you're a large entity, which means you have more than 500 employees, then you pay the most money. If you're a small, so you have large, small, and micro. So small entity means you have fewer than 500 employees, and you're not licensing it to a company that has more than 500 employees. So currently the fee for a small entity is somewhere around $730, $740. They just changed that just within the last week or so. I have filed a number of applications since then, but it's something like $740 if you're a small entity. If you're a micro entity, that means that not only are you a small entity, but you earn less than a certain amount of money in the past calendar year, or in the past year or calendar year. And the charge for that is, so the amount changes every year. It's like every time I check it, they change that amount. Currently, it's something like $213,000 a year. So if any of the inventors or any of the investors or the company earns more than $200,000 a year, you do not qualify as micro entity. If you earn less than 213 or whatever the current value is, then you can be a micro entity. And the charge for that and the patent office fee for filing a patent application is something like $360, I want to say. Again, that recently changed. Design patents are much less expensive. I think for a small entity, it's something like $360. But if you Google USPTO fees, you'll see it there. But it's a little tricky. You got to add up. There's a couple of fees you have to pay when you file an application, so you have to add them up. I'm happy to send you those costs if you email me. I'll give you the specific costs. All right. So how do you, Robert Estes asks, how do you show proper use for a service trademark? Yeah. So a service mark, people may have difficulty to understand what is a service mark. Well, if you're familiar, I don't know if Jiffy Lube is throughout the whole country, but Jiffy Lube, what do they sell? They sell the service of changing oil, right? It's not a product. They're not. I mean, you may go in there, you may be, frankly, apologies, I haven't used Jiffy Lube, but maybe you can buy certain products. Maybe you can go in and buy oil or something, I don't know. But if you use that service, or you go to a car wash or something like that, the mark has to be used it could be at the, a big sign in front of the store. It could be on a restaurant menu. It could be somewhere that is in connection with the service that's being offered. Sometimes you can use, letterhead or even emails. Just depends on how you're using it. Getting the specimen right can sometimes be difficult. I will say one more thing about trademarks is they're very nuanced, and it's fairly easy to go online at the trademark office, U.S. Patent and Trademark Office. It's combined, it's uspto.gov, and it's fairly easy to technically go through and check the boxes and fill out and file your own trademark. There's a lot of nuances to it, and I often get people who come to me, they file their own marks, and sometimes we'll just have to let it go and abandon it and refile it. You just want to be careful with what you do and what you say, but you can do it yourself. It just you may want to, like everything else with the law, all these are legal expenses, right? So your first job is to build out the company, and so that's going to make you money. This stuff isn't necessarily making you money, maybe protecting you, but not making you money. So sometimes people put these things off, and at a certain point in time, you may say, we're doing pretty well with this company. Let's go and have our books audited, whether it's a corporate, your LLC papers, your operating agreement, or your patents or trademarks. You may just, hire a lawyer to say, okay, please take a look at these things for me. Make sure I did it properly. Okay, so somebody did post, it was $130. It was a small entity to file a provisional application. Yeah, that's correct. That was Friendly 911. Robnet said, what's an average cost to file for an intent to file trademark with an attorney's help? So the trademark office fee is $350 currently, although they recently put into place a $200 surcharge if you don't follow they have certain standard goods and services. If you pick one of those, then it's $350. If you don't pick one of those, it's an extra $200. I think for an attorney to do it, it's probably $1,000 all in, including the trademark office fee. Sometimes $1,250. It will depend. I mean, some trademarks we do have a really lengthy listing of goods and services. So I'm going to move on quickly. I apologize. I'm going to move on to copyrights. Again, this protects an expression, not the underlying idea. It may complement you may have a patent. It may complement it in certain ways. At the bottom here is the proper way to indicate that you have a copyright. Either it's a C in the circle or the word copyright, the full legal name of the entity, as well as the year in which it was first protected. And you automatically get copyright protection. You don't have to file for copyright. You can start using that marking right away. Copyright, the owner's name and the year right away. But there are advantages to filing a copyright application with the Copyright Office. Copyright Office is separate than the Patent and Trademark Office. And they're pretty good over there, I understand. Their help desk is really useful. I will say this about copyrights. If you're selling a product, let's say you're selling necklaces or something like that, and you see, all of a sudden a famous celebrity is wearing your necklace or your shoes or your blouse or something that you designed or you sold, you can't just copy that off of their Facebook page or their Instagram site or anything like that. You can't just copy that image. That's copyrighted. So everything that's on your website or anything that you're using, you need to make sure that someone doesn't have a copyright in it, because people will come after you. I'm going to kind of skip over trade secrets. I'm happy to send you my slides if you want to look through that. I would like to just talk quickly about what I've seen over the years is what I call low-hanging fruit, and these are just really for any company, and regardless of size, just about. President Trump has recently changed the diversity and equity inclusion laws. You always have to be current with the laws. The laws are always changing. So, that's an instance where you may need to change your policies, your hiring policies, whatever it is. You may need to do that in order to be in compliance with the law. Corporate Transparency Act, that's currently on hold, but there was last year they were saying that everybody had to register their company with FINSA to identify who owns the companies, because they wanted to cut down on terrorism, et cetera. So that's currently on hold. I don't know if that'll come back or not. There are a lot of privacy things, and especially if you use biometrics. If your company is using, if it's taking any personal information, you have to register. So you have to give somebody your name and all that information. You have to comply with these privacy requirements. And if you're taking some biometric data, like somebody has to scan their eye or a fingerprint, there's the people are getting sued in Chicago because they have this BIPA requirement that is much different than other states. So you need to just kind of be aware of these things. What you want to do is make sure that you talk to your web designer and say, hey, are you familiar with BIPA? Are you familiar with the American Disability Act? And making sure that our website is compliant with that act. And if they say, what ADA? What are you talking about? Then you need to find another designer, because you may be subjected to a lawsuit. And I have it probably once every other year. I'll have a client who's sued for their website isn't ADA compliant, or they have a picture on their website that was from a competitor, or they have somebody a competitor that took their picture. So these things are just nuisances, and you want to avoid them by knowing what they are as best you can, and just eliminate them. I mean, if it's a picture on your website, take it off. Then you don't have to worry about being sued one day and having to fork out $10,000-$20,000 for something that really didn't give you any value to begin with. I put up here a couple of locations you can find information if you want to take some screenshots. One other thing I like to talk about, I apologize, Jonathan, if you want to break for questions, that's fine with me if you haven't been scanning lately. But there is one thing I like to talk about, because when I was in law school, they did these mock competitions where you had it was a mock trial. And there was one guy who was just like a really smooth guy, who was really Johnny Cochran type of litigator. And I was not that guy. And, I have a client who, first time I spoke with him, he was very quiet spoken. And I didn't know what to think of him. He came up with a product that he believed in, and he mortgaged his house twice, and it took him years, but he believed in his company. Today he has 300 employees, and it's great. So you don't have to be somebody who can sell the Brooklyn Bridge. If people connect with each other in all different ways, whether somebody trusts you as a source. So just recognize your strengths and weaknesses. I have a lot of clients who are great business people, but they cannot read a contract for their life. Just realize that about yourself and get help. So complement your strengths with those of others. So I'm going to take a break. I think we're really out of time. I apologize. Thank you so much for being here today. Jonathan, if you have any questions that you want to read to me, I'm happy to try to take some questions.
Hi, everyone. Thanks so much, Peter. So, Peter, I believe I think we'll probably just not do audience member questions. We can, folks, we've included information at the bottom of the stream. So you can read, if you have any additional questions, you can reach out to Peter directly and connect with him on LinkedIn as well, and also on the screen as well. Unfortunately, we are out of time. I know we could probably go on for a long time with this kind of content, and I think should our audience stay so in the feedback survey that we send out, we'd love to bring Peter back again for maybe a part 2 continuation of this, just because this is a very important topic. But fantastic presentation, Peter. And thank you to all of our audience for tuning in and for your great questions. A few announcements before we end things today. First up, pardon me 1 second. In case you missed it, IEEE-USA is sailing to the Western Caribbean in 2025. From the tropical beauty of the Bahamas in 2023 and the majestic splendor of Alaska in 2024, our cruising saga continues in 2025 to the Western Caribbean. IEEE-USA will be hosting a 5-night Western Caribbean cruise from October 27th to the 1st of November. We'll be cruising in style aboard Royal Caribbean's Mariner of the Seas from Galveston, Texas, to stops in Costa Maya and Cozumel, Mexico, before concluding our cruise back in Galveston. We'll be opening up the booking portal soon, and you can find out as soon as it does by signing up for email updates on our cruise website. The link has been provided below, as well as the comment section. 1 moment, please. Next up, registration for our 2025 IEEE-USA Congressional Visit Stay which will be held April 8th through the 9th. CVD is an annual event that brings IEEE members to Washington, D.C. to raise the visibility of and support for engineering and technology. It's a rare chance to introduce yourself, your colleagues, your company, and your profession to our elected officials. It's also a great opportunity to discuss legislation and issues that are uniquely important to IEEE members. The link has also been provided in the comment section. And finally, we have some exciting news for aspiring cybersecurity leaders. The Nexus Cyber Institute, a collaborative effort between IEEE-USA and Boots to Cyber, dedicated to addressing America's growing need for skilled and accredited cybersecurity professionals, will be hosting a Certified Chief Information Security Officer, or CCISO, training in Huntsville, Alabama from March 24th to 27th. This executive-level program is designed for professionals aiming to excel in the highest echelons of the information security field. So you definitely don't want to miss this chance to enhance your expertise and become a leader in cybersecurity. Definitely register now to secure a spot as soon as possible. If you enjoyed the content presented in today's webinar, be sure to check out our extensive catalog of other presentations and publications available on demand on our website for your viewing pleasure. And finally, if you haven't, be sure to like and subscribe to our social media channels, and don't forget to check back daily for updates on our upcoming events. Have a great day, everyone.
Your IEEE membership means access to insurance products featuring exclusive group rates, flexible benefit options, and portable coverage that stays with you throughout your career. Engineered to help protect your loved ones and your financial security. For more information, go to IEEEinsurance.com.